necessarily in this order, I might warn you, but I'm going to go first. We probably will leave all the questions right till the end because we've got such a variety of topics to cover between us. So we're going to look at what happened over the last year during 2017 and looking ahead to 2018. Legal professional privilege, I'm going to touch on that tricky subject and update you because there's been a really key case in the last year that you might want to know about. I'm going to do a case update, mainly focusing on some of the recent appeals. Corporate, I'm going to focus on. And then I'm going to move into a little bit of a fire safety update. How many of you are responsible for fire safety in here? Can I have a little bit of a show of hands? Yeah, so it'll be relevant for lots of you. But I haven't focused heavy on that, just some of the key changes. Obviously, I don't need to say why that's so relevant. Anyway, now everyone's interested in it. And then Richard is going to move on to personal prosecutions and gross negligence manslaughter, and then some of the other recent changes to come and over the last year. So I'm just going to touch on very quickly ISO 45001. So as you are all aware, it's aiming to provide a framework to improve employee safety, reduce workplace risks, and create better, safer working conditions all over the world. So this is designed to be integrated into your current health and safety systems. The second draft was circulated in April 2017, and I think at some point people wondered if it was ever going to come to a final version and conclusion. But it's looking like the final version has been accepted and it's going to be published in March 2018, so we can have a look at that, and I'm sure that the next update you go to will have more detail on that. And this is going to replace the OSAS 18001, as I'm sure you know, but there'll be a 3-year transition period, I understand. So Brexit, again, very briefly touching on this because I think we've probably all been bored to death of this on the news. But basically, as you're all aware, in June 2016, the UK voted to leave the EU. Theresa May then triggered Article 50 in March 2017. So we're all on 2 years' notice of leaving the EU. It's created some uncertainty, certainly at the beginning, for businesses. How's this going to affect regulation and what's going to happen? The general opinion among health and safety specialists is that it's not going to have a massive, dramatic, sudden impact on health and safety regulations by virtue of the Great Repeal Bill, which will become the Great Repeal Act, then, which is incidentally next week got its third reading in the House of Commons before it goes up to the House of Lords. That will allow for EU legislation to be transposed into UK legislation, so everything will just continue as normal, and then we can expect changes if they're going to happen slowly over a period of time, and it will be a different world that we're living in then, because it will change according to the whim of the government of the day in that scenario. So although government have talked about reducing regulation, I really can't see, and especially in the light of Grenfell, any move towards deregulation in health and safety, and I'm sure that everyone is of a similar view. So nothing to panic about with Brexit, I'm sure you're pleased to hear. So a slightly more detailed topic, legal professional privilege, and I'm sure that this is something which lots of you have had to think about in the past, but it's something to be concerned about with regards to how you carry out investigations into workplace incidents, how you carry them out, how you go about getting advice in relation to them, and then whether it's disclosable to regulators if you are then under investigation. And that's why legal professional privilege is something that's really important for you to concern yourselves with. So what actually is legal professional privilege? What's the point in it? So it's a fundamental human right which is guaranteed by the common law. It's a really important principle in the administration of justice because basically it allows you, anybody, any individual, any business, to go and get advice in confidence from a solicitor or any other lawyer and be confident that the information that they hand over to that lawyer is then not going to be shared with the world. And in particular with enforcing authorities, be that the police or the HSE or other enforcing authorities. And it's really important that we are free to go and get that advice in confidence. So once a document is privileged, that is an absolute. It can't be overridden by any other kind of rule. And then it means, like I've said, the document's not disclosable in legal proceedings. However, and the reason we have to really think about it is that this isn't about writing the words legally privileged across the top of a document. We do that because it does help sometimes indicate that that was our intention in relation to that document, but that doesn't actually give a document legal privilege. It can be waived, privilege can be waived expressly or very often inadvertently. So if you seek some legal advice, you've got it in a documented form, and then you go and hand it over to a regulator, then you're waiving privilege on that document. And that means really that document can then be shared. Or you might not hand it directly to a regulator, you might just hand it out willy-nilly within your own company. And that can have an impact on whether the document is still privileged. And we'll come to a bit more of the detail about legal privilege in a minute when we consider the recent case. But the rules around privilege have become tighter recently, which is why I'm mentioning it to you, something to consider even more carefully. The main types of privilege, there are other types, but the main types, legal advice privilege, so that's when you're receiving legal advice from a solicitor. This doesn't have to be when there's litigation, just bog standard asking solicitor for advice. And then there's litigation privilege, which is during or in contemplation of litigation. So, the recent case, has anyone heard of this? Does anyone consider legal privilege enough to have heard of this ENRC case? Okay. To be fair, you're not really missing out because it's a fraud-related case, but the rules which are expounded in it affect you guys in relation to health and safety investigations in your business. So, ENRC is a company, and the SFO is the Serious Fraud Office. And the Serious Fraud Office were investigating the company ENRC. And this was following allegations of fraud, bribery, and corruption. And ENRC, actually, before the SFO started to investigate them, they conducted their own internal investigations and review of their operations in Kazakhstan, but that's kind of irrelevant. So already you're seeing some similarities perhaps with some scenarios you might face in the workplace. There's an incident, right, we're going to carry out an investigation, even if we're not yet being investigated by a regulatory authority. So they appointed some external solicitors to carry out this internal fact-finding investigation, and then the SFO began to investigate, and they commenced action against ENRC because ENRC said, well, you can't have any of these documents that we've been discussing with our lawyers because they're all legally privileged. And the SFO said, no, they're not all legally privileged. We're going to test this. And they took them to the High Court because it was a civil case. So they went to the High Court. ENRC said the documents are subject to legal advice privilege or litigation privilege. And the court ruled against the company. And the court said most of these documents were not privileged. And I'm going to go through with you the different types of documents, and you will be able to see how they are probably similar to items that you guys might produce in the course of investigation. So there was interview notes, and the interview notes were notes taken by lawyers when they were carrying out this internal investigation. So they spoke to employees, they spoke to former employees, they spoke to subsidiary companies, they spoke to suppliers and other third parties, and they were the lawyers' interview notes. And they said, well, this is subject to litigation privilege because at the time we took them, we were thinking that because of this potential fraud or bribery, but really that's the same as thinking, well, perhaps we have breached some health and safety regulation. they were thinking, well, perhaps we breached some regulations, we need to get some legal advice. So they said, well, litigation privilege could apply because we do think that we might be subject to litigation. And they also said legal advice privilege applies because even if we weren't being subject to litigation, then we were just getting advice from our solicitors. And the court held, no, it wasn't litigation privilege because litigation wasn't in reasonable contemplation and wasn't the dominant purpose of the production of this material. And the court basically said, until you're prosecuted, litigation isn't in reasonable contemplation. So even while you're being investigated and your solicitor's saying to you, unfortunately, I think there's quite a high chance that you might be prosecuted here, was the decision in this case. And not legal advice privilege. No, they said these are all communications with third parties. It's not direct client-lawyer. So no, there's no legal advice privilege either here. And so accountants' reports. So this was, they did a review of their books and records. This is a fraud case, so it's very relevant for them to be reviewing books and records as part of their investigation. And yeah, again, the court found no, not litigation privilege, because litigation wasn't the dominant purpose of you creating, doing this review and creating these reports. Factual updates. So here, they said, well, this isn't litigation privilege. And what the factual updates were that the lawyers had created presentations for ENRC, for the company, for the board, and they delivered those to the board. And it was about the internal investigation that they'd done. You know, here is the legal advice that we're giving you. And this is what we found during our investigation. And no, the court said that's not litigation privilege because you weren't prosecuted yet. Litigation's not in reasonable prospect and not the dominant purpose of what you were doing. But they did allow legal advice privilege on that part. So one thing was successful. And then we had communications with a legally qualified businessman. And what that basically was an internal employee who was head of one of the departments, who was a qualified lawyer, and they'd gone to him for some advice. And they said that was legal advice privilege. We're going to a lawyer, fair enough, it's internal, but we're going to a lawyer for legal advice. And they said, no, he's acting in the course of his business. He's not acting as a lawyer. Ooh, so that's a pretty harsh decision-making there in terms of legal privilege. So the legal world is quite shocked by this, and we all hurried along to talks by the barristers who conducted this case. And this is being appealed, you will be pleased to hear. So it continues, and we hope that there will be some relaxation of this new world. But that probably won't be for a little while, and in the meantime, this stands. The thing to bear in mind, and what I'm going to come on to now, is that it's not necessarily as bad as it first looks when you really get down to the nitty-gritty of reading the case of ENRC. And one of the key things to bear in mind is that at the stage where the court held that legal advice privilege or litigation privilege didn't apply, the SFO were in a more collaborative discussions with the ENRC. So they were working towards information finding together. And so there will be ways in which when your lawyers or your companies want to rely on legal privilege, there will be ways in which you will be able to distinguish your situation from this ENRC case. So now the position with legal privilege post ENRC, what are the things to think about? So legal advice privilege is still confidential communications between lawyer and a client, and this is really key. The lawyer is a lawyer, so not necessarily the internal person who's not even employed as a lawyer in the company. And the client needs to be a distinct specified client, or if not an individual, because often in large companies, when you're advising them, a client will actually be a group of people, but they need to be a defined group, as defined as possible. And the more the information and advice you receive from lawyers is spread around, which is so easy by email, the more it's spread around, the more likely that you would be found to have waived privilege. So that's why lawyer and client is really important. Legal advice privilege, again, still no litigation is required. Remember, it attaches to all connected material. So if you carry out an internal investigation for the purposes of seeking legal advice on a scenario, and you receive it and you've identified who your client group is for the purposes of retaining privilege, but then you go and distribute that amongst loads of people, then the privilege attaches to all of the connected material, so all the things that you refer to within that. So it might be a whole load of witness statements, for example, from employees that you refer to. If you've waived privilege on everything in the background to that document. So it's very important to keep control of advice and material if you find yourself carrying out an internal investigation. And then legal advice privilege, more one for me to worry about, I guess, and Richard, doesn't apply to lawyers' working papers unless it includes legal advice. So that's really one for the lawyers to think about. Litigation privilege, so this is still where it's confidential communications between a lawyer and a client, a lawyer and a third party, so third party, perhaps an expert, so that still retains privilege, or the client and a third party. So imagine if you've got an expert, that's the easiest third party, but it's got to be for giving or obtaining legal advice, and that has to be what the dominant purpose is. Litigation has got to be in reasonable contemplation, and this case has drawn into question what that is going to be. Of course, we will still be arguing that during an investigation process, litigation is in reasonable contemplation, but this ENRC case does draw that into question. The dominant purpose has got to be conducting litigation and not avoiding litigation. So that's one to kind of remember and think about. Litigation's got to be adversarial, as I've said already, not just an investigation. And yeah, as I've said, potential adverse inferences for internal investigations. So that's like a quick roundup of this quite a long-running serious case. But I hope that gives you an overview of why you ought to be concerned about it when you're particularly carrying out investigations at work, and just something to think back about and think, right, what do I need to do about this? So, some recent cases. So, Tesco Stores Limited, I'm sure that you have all read about this. So, over a 29-hour period, 23,500 litres of petrol leaked from, it's just a petrol station, one of the company's petrol stations. It wasn't any sort of other type of facility, just a local petrol station, into the sewer system and water course. This actually happened in July 2014, but it's just come to a conclusion. So this massive multi-agency operation with the Environment Agency, it was Lancashire County Council, United Utilities, Fire and Rescue Service, the police, a huge operation. People had to leave their homes because of the fumes and the odour. The local rivers were polluted, and they said that a week later, there were 90% less fish downstream of this incident than upstream, so quite a considerable environmental impact. And there was a joint investigation between the authorities and joint prosecution with the Environment Agency and Lancashire County Council. And really what they found was this was actually a known issue. And it being a known issue is something which is a theme in a couple of the cases that I'm going to talk about. They knew that there was a potential problem with their fuel delivery system. There was an inadequate alarm system and poor emergency procedures. And this was known. So turnover of Tesco's, 39.8 billion. And so in total, an £8 million fine, 5 million for the health and safety breach, and 3 million for the environmental offence. We have seen, I know that you will be aware, some really huge environmental offence fines. So overall, not anywhere near the biggest environmental one, but £8 million is a significant fine, and £57,500 in costs. I'm quite surprised the costs weren't higher, but I don't know what the reason for that is. So this is suggestive of a high culpability and harm category 1 case, but not particularly that Tesco's been treated as a very large organisation, despite their massive turnover. And just remember, there were no fatalities in this case. There was discomfort and annoyance caused to local people, but no particular injuries and certainly no fatalities. But lots of people were exposed to a risk of harm, and we all know it's very much risk-based, isn't it? So that's a key thing. Okay, now on to Whirlpool. I realised as I got here that this is a local case, so I embark on this with slight trepidation, and Richard is giving me a big grin, which suggests he might know something I don't know. But anyway, you'll have to forgive me. So hopefully I'm not going to say anything too dramatic. So Whirlpool factory in Bristol, they're a tumble dryer manufacturer. So they had a scenario where a subcontractor was moving a heat detector, and he was standing on an elevated platform between conveyors which had baskets hanging down, which I understood carried the tumble dryers around. If we've got anyone from Whirlpool in here, I'm sure that you'll probably be able to describe that better than me. But anyway, that was what I understand the scenario to be. Elsewhere in the factory, and this had been arranged for a weekend, when apparently this conveyor wasn't meant to be in action anyway. Elsewhere in the factory, there was maintenance of the conveyor belt was going on. And so, but the conveyor belt maintenance operatives couldn't see the person moving the heat detectors. And they, as part of their maintenance, they started the conveyor belts, and this knocked off the guy doing the heat detectors from his platform. And unfortunately, he suffered fatal injuries. So they pleaded guilty to a breach of Section 3 of the Health and Safety at Work Act. They had an inadequate risk assessments for the maintenance, inadequate permit to work in relation to the heat detector, and they crucially hadn't worked out that these two independent people were coming in at the weekend and going to do work which clashed with each other in health and safety terms. So they hadn't worked that one out, and so hadn't risk assessed it. So, low culpability case and a harm category 3, and their original fine was £700,000. But they appealed it. So, when on appeal, the starting point of the fine was reduced from £1.2 million. So in the original case, the court had started at £1.2 million as a starting point. And actually here, in this case, when it went to the Court of Appeal, the judge said, no, actually, the starting point should have been £250,000, increased to £500,000 because of the size of the company, and the starting point was lower because of the low culpability. So the Court of Appeal started at £250,000, and they then increased it to £500,000 because of the size of the company and because of the fact that death resulted, and then they reduced it. You can see, gone the wrong way. They reduced it then to £300,000 on appeal. The issues in the appeal, and the reason for mentioning it really, was that where the court started off at this £250,000 and then said no, death resulted, and this justifies moving up a category range. So they were very specific about the fact that the death resulting justified this big move up. And I think when you actually read the words of the judgment, it was said in very specific terms. So this is something that I think we need to think about if we find ourselves in this horrible scenario we're being investigated in relation to a fatality, actually, potentially, we're going to move up a whole category in the sentencing guidelines because of this. And identification and treatment of very large organisations, very specifically, fine was increased because of the fact that it was a very large organisation. But the court was keen to express that you shouldn't take an arithmetic approach to this. So it wasn't like they came up with some kind of calculation, because that would make it far too easy for everyone. So they just discouraged this arithmetic approach and said that, well, this reduction in the sentence is very much because of the facts of this case. And it's because the case basically was low culpability. And the Court of Appeal reminded the lower courts that even when there is a fatality, they still have to think very carefully through if it is a low culpability or low likelihood of harm case. They still have to analyse that very carefully. And we're not necessarily coming out with the most huge fines, even for such a large company where there's been a fatality. So now I can move on to something not local. So, although it's not that far away, I think it's in Wales. So Tata Steel, the case actually started Tata Steel UK, but was sentenced on the finances of Tata Steel Limited. And in this case, there were 2 employees suffered injuries, and this was to do with inadequate guarding. And in the first case, and both employees who were injured suffered really significant hand injuries. The incidents happened 5 months apart. In the first incident, the employee actually removed the guard, but it was found that actually that had become common practice. And so it's just that there was inadequate guarding. And then they pleaded guilty for the 2 breaches of under Section 2 of the Health and Safety at Work Act. And the interesting thing about this case is about the difference between the fine for the first offence and the fine for the second offence. So in the first offence, they're fined £185,000, bearing in mind the very similar facts. And in the second offence, £1.8 million. What a massive difference for 2 very similar offences. And this comes back to the being on notice of the issue. So, Tata Steel Limited had a turnover of 40 billion. But you can see here, where I put in the different sections of the sentencing guidelines, you can see that the different parts of the guidelines that the court looked to. But you can also see that for the high culpability, which was the second offence, because they already knew about the issue, it was a £1.1 million starting point. And this was really the kind of basis of the appeal, because the court actually, when it sentenced the second offence, gave a starting point of £2.4 million. And they said, taking into account the turnover and wanted to have, and then they increased the starting point again, £2.75 million, and said, we want to have an impact on the shareholders. So it was appealed. It was appealed on the basis that they said the judge made errors in sentencing in the first offence, and the Court of Appeal said, no, that's fine. This is not a manifestly excessive fine in relation to this and overall. The judge shouldn't have moved outside the category range for the second offence, and the court said no, they can do that, that's fine. Unsuccessful on these points. So the judge should have made a downwards adjustment to the fine because the business was making a loss. And Tata Steel, it was even in the news, the big losses that they were making. And there were going to be loads of layoffs apparently. But actually, it turned out that this overall fine of just under 2 million was only the equivalent of 0.6% of the usual loss that this company operated at. It was operating anyway at such a massive, great loss. The court just said, well, this bit of fine is not going to put you out of business. You're operating anyway at this huge loss. So no, they just ignored that part. However, another point of the appeal was They said, no, the judge has incorrectly concluded the offence involves a high likelihood of harm, and it should be a medium likelihood of harm. And they looked there at the number of working hours that had gone into this type of machinery before the incident happened, so in between the two incidents. There'd been something like 150,000 hours of work done on this equipment. And what they argued was, well, what Tata argued was, well, that there can't be a high risk likelihood of harm if we've operated it over all those hours without any harm. And the judge agreed with that and said, yes, it shouldn't have gone, just because the second accident happened, it shouldn't have gone up to a high likelihood of harm, and agreed that it should have been a medium likelihood of harm, and said that the starting point, therefore, should have been the £1.1 million. And they brought it down, the fine reduced then overall to 1.5 million. So the fine for the second offence was reduced. So a successful appeal, but not massively greatly successful. Okay, so on to some NHS trusts. Does anyone work for an NHS trust? Oh yeah, someone over there. In public sector, anyone? No? Oh yeah, a few public sector employees. Okay, great. So these are particularly relevant to you guys. So Norfolk and Suffolk NHS Foundation, they had a patient admitted to a mental health ward. She was under observations every hour, and then this was reduced from 6 observations every hour, so basically keeping an eye on her most of the time, to 1, and there was no risk assessment done. And less than a month after being admitted, she was found drowned in a bath. Very sad case. And they pleaded guilty to breach of Section 3 of the Health and Safety at Work Act. And essentially the problem the problem actually on the ground had been that the bathroom doors were meant to be locked, and they weren't, manually just by the staff, and they hadn't been. But the previous day, and there we come back to knowing about a problem, the previous day someone had seen her having access to the bathroom and running herself a bath, even though that was not something safe for her to be doing on her own. They'd stopped her doing that on that occasion, but the very next day, unfortunately, without anyone seeing, she'd gone and done the same thing. So they knew, had some knowledge that this was potentially a problem. So they were fined. So the fine starting point, 1.1 million, and that was reduced by half to 550,000 in the first instance, because they are a public body. So a very distinct 50% reduction, which we've seen in other cases as well, because they're a public body. And then after the 50% reduction, it's a full credit for the guilty plea, which is a third off. So they went down to £366,000. And they appealed that. And they said they hadn't got enough credit for their mitigating factors, and that the court hadn't addressed the ability of the defendant to pay the fine. And I know this is always, when we have public authority clients, this is always a major issue. This is public funds that is now just going to pay a fine. So, but the appeal was not successful. The judge said, no, it wasn't manifestly excessive, and this was a totally reasonable sentence. And you can see there was a 50% reduction, so it seems logical that the judge came to that conclusion in the light of the guidelines. And then there was a similar matter, which I don't have a slide for, which was Shrewsbury NHS. And they had 5 deaths from falls over a fairly, I think it was about an 18-month period of time. And in that case, the judge relied on health and safety executive statistics about how likely it was that someone over 65 would die from a fall. And actually, the conclusion from that, there was a fairly low likelihood of harm. And there, again, they said, well, in a commercial organisation, it would have been £1 million fine. It was reduced for 1/3 for a guilty plea, and then reduced 50% because it was a public authority. So that brought them out with a £333,000 fine. but a pretty massive cost of 130,000. Actually, in that case, the judge did the reduction for the guilty plea before the 50% reduction because they're a public authority, so they actually ended up with a little bit more off. So they won't be appealing that one. And so Pound Stretcher, and I'm just mentioning this, the only reason I'm mentioning this, it's got a really good parallel with the fire safety case that I'm going to mention. And just the actual circumstances are so similar, but it shows the difference between a health and safety sentencing and fire safety sentencing, which I'm sure is going to change in future. But at the moment, this is how it is. So they were sentenced, Pound Stretcher, this month, 24 breaches of the Health and Safety at Work Act, and basically they have a store where they've arranged the warehouse so messily that emergency exit routes are blocked, and you can see some quite boring photos of it online, boxes and things like that blocking passageways. And Pound Stretcher somehow seemed to have managed to quite annoy the judge. I'm not sure how this is what happened, but the judge said, and they seem to have come across that Pound Stretcher have blamed the local management team, which is not a very good idea when you're at court, but they blamed the local management team, and the judge said that was extremely unattractive, which is probably quite a polite way of putting what he was thinking. And he said that there had been a complacent attitude to the HSE by the senior team, and the lack of cooperation by the senior team was reflected of the attitude to the regulator. And they specifically said, and I think this is quite important because they specifically said, the court said, you have, you've acted within the realms of your legal rights, but actually this just reflects a poor attitude. And this was mentioned as an aggravating feature when it came to sentencing. So it's really important how you deal with the HSE. And that's not to say that you give them everything they ask for and do absolutely everything they say and jump through all their hoops. But how you go about defending an investigation is incredibly important, because here for Pound Stretcher it definitely panned out badly, having come across like that. And blaming other people, blaming people lower down the chain is always an extremely unattractive thing to do as far as the court is concerned. So they got a £1 million fine and £65,000 costs, which is quite a lot cost-wise. So, I mean, cost-wise, that is sort of significantly above an average sort of case like this. And I think that they must have, it's another thing to be aware of really, I think Pound Stretcher possibly by the way they conducted themselves from the sound of the judgment, I really hope there's no one from Pound Stretcher in here, I just thought that. Anyone from Pound Stretcher? No? But the way they conducted themselves, I think they might have incurred themselves extra costs. And that's something you want to be aware of when you're dealing with regulators. So fire safety developments. This is only going to be quite brief, but because I know it's not fire safety talk, and you don't all do fire safety. But here is a case from October last year with JD Sports, and it was Christmas 2015, and they had overstocked the kind of back storage area. And I'm sure that there's probably quite a common problem for retailers at Christmas. And so they had an overstocked back area, so they blocked fire exit doors and routes. And this problem actually was identified 18 months before, so we're coming back to this knowing about the problem issue. They'd identified it in their own risk assessment 18 months before, and then the fire authority turned up. And the fire authority identified the problem and asked them to resolve it. And then came back a couple of weeks later, and they still hadn't done anything about it. So not surprisingly, they were prosecuted, but there was no fire in this case, just like with Pound Stretcher. And they pleaded guilty to 6 offences under the Regulatory Reform Fire Safety Order, and they got a £60,000 fine. So, wow, what a difference from £1 million to £60,000. well, on the face of it, sounds like a fairly similar case, but this is because fire safety matters are not sentenced under the Health and Safety Sentencing Guidelines. So fire, and in fact, I wrote an article about this case when it came out, saying that if this had been a health and safety matter in the same situation, it would have been a much higher fine, and then lo and behold, in January, Pound Stretcher get the £1 million fine. The way that Pound Stretcher conducted themselves is not going to help them, and in comparison, JD Sports did seem to have done everything they could to rectify the situation, and they moved premises and they changed their systems and everything to try and stop this happening again. So how they conducted themselves had a difference, but the main difference is that the sentencing guidelines don't apply to fire safety cases. So if that changes in future, then the sentencing will obviously also change. So let me come on to, this is my last bit before I hand you over to Richard. Dame Hackett's interim review of building regulations and fire safety. So she was appointed by the government after Grenfell to lead this independent review. It's into building regulations and fire safety following the Grenfell fire. And this is separate from the public inquiry. And an interim report came out, I think it was just before Christmas, certainly very recently. Her interim report came out, and the full report is due in the spring. But essentially, she is proposing a wholesale regulatory and cultural reform to the building regulations and fire safety regulations. She says, in the long term, we'd like to see it look more like health and safety law, with a risk-based approach, which we currently have, and standards which set frameworks or goals. I don't know how many of you work within building regulations at the moment, but it's quite factual and prescriptive. So she's looking to move away from that. The final report is likely to recommend responsibility by named senior individuals, completely new legal duties, and new criminal sanctions in relation to this. So it looks like there is going to be quite a big change, and particularly in relation to the building regulations side of things. And a key theme in her interim report is about competence and qualifications of people who design, construct, inspect, maintain high-risk or complex buildings. So there isn't a particular competence and qualification regime at the moment, and she's saying that industry and professional bodies and accreditation bodies are put on notice that they must work together to improve this situation, and they must work together because otherwise there's going to be legislation about it. So quite often that's a kind of tactic that we see happen, that instead of legislative change, there's a kind of threat that if you don't do that, there will be legislation, and the kind of industry and professional bodies would rather avoid to these things, so they usually get together to resolve the situation before it comes to that. So that's what we can expect to see. And the new scheme might involve registration of individuals, but we'll just have to wait and see. And a tightening of fire risk assessment requirements as well, to make them specifically annual rather than just regular, which is what it is at the moment. And also with a requirement to share them with residents if you are responsible for the fire risk assessment for a property which has people living in it, and a requirement to share it with the fire authority. Although that has raised some questions really, because I don't know what the point in sharing a risk assessment with the fire authority is if they don't then have any duty to review it or do something with it. But that seems like something which would probably be a bit too costly. So we're going to have to see how this pans out in the final report, which is due in the spring. Okay, well that brings me to the end of my section. I'll pass over to Richard, and then I think we'll do questions about the whole thing right at the end. Is that okay with you?
I don't mind, whichever.
I think me and Richard think that would be the best way, because we might end up getting questions which are about things he's about to cover. And there are some very interesting brochures at the back on a table, which Kevin, the lovely Kevin Bridges, gave to me to bring. So hopefully they contain some useful information if you want to get them on the way out. Thank you. Thank you.
Going backwards. That was very good, excellent. Sort of timing that I can only aspire to, I think, getting it done through. Well, while I'm getting my water, first question then, Judith Hackett. Where's she from? HSE, yeah, Dame Judith Hackett. So, you know, they never die or go away, do they? They all carry on. So it's anyway, so this is sort of introduction to what I'm going to talk about later, which is the individual gross negligent manslaughters. And you've seen all this before, so I'm not going to dwell on it because we discussed it fairly briefly last year. But if you remember, we were talking about the increase in personal prosecutions, how it increased and it went up 3 times last year, et cetera, from a request for information, freedom of information by Clyde & Co. And there's been all sorts of talking and writing and articles and shenanigans about this ever since. So I'm going to add to it. Back to Dame Judith, she's haunting me. She wasn't there when I was there, but I've heard about her. Personal prosecution, immediate sentences, those sort of things we talked again, those who received immediate custody, there were gross negligent manslaughter, there was some health and safety section 3, and gas safety. Gas safety, obviously very immediate, usually members of the public, can be children and things like that, so quite emotive, and everybody gets, you can see why gas safety would be part of it. Would be easily done to do that. That's quite a nice one, nice tune there. Right, personal prosecution, carrying on again, suspended sentences. The fact is, yeah, you get all these custodial sentences. Custodial sentences is slightly misleading in a sense. Oh, you've been given a custodial sentence doesn't mean necessarily you're going out of a different door than the one you came in court. It means that it's considered past the custodial threshold, and it's got these points on there, but it can be suspended, and most of them are suspended, particularly the health and safety, except for those ones we just talked about. Their sentences only under 2 years can only be suspended, so that's obviously going to be most of the ones that we're interested in when we look at the sentencing guidelines briefly in a minute. So when is suspension appropriate? Strong personal mitigation. So who are you punishing? Are you punishing this person, or are you punishing this person's family, or are you punishing this person's organisation, because the organisation will be threatened by this person disappearing, etc., etc. All those things come into it. And I've been through this process quite recently with a case, and pointing out to the judge that, yeah, custodial sentence is available, but is it appropriate for the various reasons, and what are the ramifications of a custodial sentence, not only personally on the person who's being prosecuted, but also on those people around them. So, going on to that, so we're getting quickly through these, as I say, because we've done these before, so let's just whip through them. Court must consider ancillary orders, so, you know, it can be disqualified a director, so we've got that on top as well. We've got the cherry on the cake on top of that. We're coming at you, giving you a custodial sentence, and we're going to take away your ability to be employed as a director in the future. And again, it's all about individual cases and what they did, and whether they conducted themselves as a director should, and all those sort of things sort of come around and taken into account, and whether you're going to be suspended or disqualified is a correct thing, and how long that disqualification is going to take place. Little sting in the tail down here. More likely the closer the director to the job in question. So what does that mean in health and safety? My usual, one of my bees in my bonnet's coming out here. What does that mean?
Guiding light.
Exactly. Good. It's controlling life. You're lower down, smaller organisations, if you could be identified to what's going wrong. So again, this discrimination between large organisations and small organisations there. So maybe I'll get onto that a bit more. Personal prosecutions, culpability. Again, familiar stuff. We've had this over and over again. Very high, high, medium, and all the words that we know about. Intentionally, breached and flagrantly, etc. Down to low. Again, remind you of the words there. Significant efforts were made to address the risk, although they were inadequate on this occasion. There were no warning circumstances indicating a risk to health and safety. Failings were minor and occurred as an isolated incident. So actually, I know I'm talking about personal, but just to really confuse everything, talk about something that Laura just said about it. Was it Whirlpool? They had low culpability there. So they had the low culpability there. And you think, well, low culpability, and words sort of transfer over to the corporate side of it as well. I mean, that's a health and safety offence for the company. Absolutely confusing the issue completely here, but let's bear with me a bit. So this is an individual. This sort of language here transfers over when you're talking about an organisation, low culpability. So why are they in court? This sort of thing. Surely people have got better things to do than chase people with culpability described in a language like this. But I suppose in the Whirlpool thing, as Laura said, there's fatality there, we bumped it up. And got a significant fine there. So just point that out. And we go to custodial threshold. So personal prosecutions, again, we're back to the personal, back to the individuals. So we've got our culpabilities there for high and very high, and 26 and 18 months and all those sort of things we expect to see when you see high culpability, etc. But down to low culpability. Think of those words again. That low level of culpability, you wonder why they're being prosecuted, and yet 26 weeks custody is there. It's there on the consideration. And I expect Laura's experience the same. You talk to any director or any senior person, you say, and they're in this situation, talking about it, and they say, can we go to jail? I say, no, look, it's right at the bottom there. Oh, but it's still there. It's still there, and it's still eating away at there as the possibility there. Okay, so what does it look like? So let's bring it back up. People aren't sort of queuing up, with their overnight bags at Horfield Jail at the moment. So that's why. What does a sort of custodial sentence look like? We've got massive destruction there, massive universe. Employee, Mr. Safi comes killed, becoming entangled in a waste trommel. I think Jack, my colleague there, actually got us a fantastic piece of machinery there, under there somewhere. And that's what happened there. And no safe system of work, essential guards missing, no emergency stop button, machine in a dangerous state. That's what you expect to sort of hang around somebody's neck when you think, well, it's time for the overnight bag. So that's the sort of thing. Company convicted of corporal manslaughter, Mr. Singh convicted of Section 2 of the Health and Safety at Work Act, and an offence there. So, also, company paid £220,000 fine in costs, plus costs. Mr. Singh, 12 months imprisonment, suspended for 2 years, 300 hours of community service, disqualified as a director, breach. So, case this year, all those things about low culpability, sentences available, it's there for people. This is quite a significant event, and you can see what the sort of the smell of the guidelines from that effect. He's got the full range there. He hasn't got quite going into jail, but he's disqualified. He's got community service. He's got a suspended sentence. So, bingo. He's covered the ground for us. Okay. Another little case here. Unnamed employee fell through fragile roof, 2015, but obviously only come to fruition in court last year. Fractured a skull, pelvis, blah, 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 potential for fatality. Conscious decisions were made not to use safety netting under the fragile roof. So I suppose that's quite a key phrase there, conscious decision made. So that would indicate that there was knowledge. So knowledge is there, and most people would know anyway if you're in the business that netting is available, but obviously that's quite key there. Standing over, it's less sort of echoey over here a bit, so I'll try a bit over here. Personal prosecutions, example case, Punley pleaded guilty, fined 54,000. The turnover information is a bit obscure there, so I imagine it's quite difficult to pin them down. Pay cost 12,000. Mr. Dobson pleaded guilty as a result of his consent, connivance or neglect, 7 months imprisonment, 150 community service costs, etc. So again, giving you an idea from a case of recent times of personal consequences leading to court. Right, so on to the bee in my bonnet. Increased enthusiasm for personal prosecution, increased risk for directors. And I've given this talk, and we had a discussion in this AOSH group quite recently, and Julian's got quite strong views on this, I remember. And it was, so is this a good thing? Is this a good thing? Probably, you know, you think about the arguments, personal accountability, it sort of sounds all right, sort of messages getting across to people. No sign of increased in pursuing employees themselves, so Section 7 type things. Anybody got any views?
They got no money,
There you are, hand that goes up straight away, sorry.
I think the typical
Come back to you.
cowboy doesn't know about these cases.
Sorry?
I think the typical cowboy doesn't even know about these cases.
No.
So in the forefront of their
So that's quite good then, you know, these cases are there for perhaps for those people. Sorry, you're going to say something?
I was going to say the employees, they won't pursue the employees, they've got no money.
They got no money. But it's not necessarily that. They, you know, all prosecutions are means tested anyway, so they take that into account. So whatever money they've got, they'll take a percentage. But I'm interested in your point there, the cowboys on that. So what, from my sort of view is, yeah, personal prosecutions is a good thing. It brings forward health and safety to the forefront of people's minds. It does focus the mind. This idea, you know, that you might be sharing a cell with somebody you've been trying to avoid all your life, the type of people and all those sorts of things. But what does it do? What's the attitude? What sort of attitude is it going to come across? Is it necessarily a good thing? It's going to bring it forward to us, all those good things, but is there any negative side of it? Just while we discuss this, IOD, HSE core actions. Remember, the Institute of Directors, that friend of health and safety in the past, they come out, joint discussion document with the HSE and then joint guidance on how successful leadership in health and safety. This document came out with sort of full fanfare, cooperation with the HSE, with the Institute of Directors. We're looking at health and safety and looking at leadership of health and safety. We're looking for those people who can make a really big difference in health and safety, stepping up to the plate and making that difference. And this is the sort of route map and roadmap we're going to help them to do it, and this is what it looks like when you do it. So, set out board members' requirements to lead health and safety constituent, own and understand the key issues, communicate and promote those issues. Health and safety arrangements must be adequately resourced, competent advice obtained. Well, listen, that's owning it, communicating, promoting these issues. So leadership, as I say, by people who can make a difference. These leaders conduct periodic audits and into the effectiveness of management, ensure that major accidents, changes and procedural alterations are reported to the board. Procedures are in place, new altered legal rules. So again, this emphasis on the leaders. Okay, annual reviews of the Board of Appropriateness to Health and Safety Policy, all those things. So, back to those previous slide, if it'll work there. Yeah, okay, employees, back to that. Is this a good thing? Let me just go back. Where was it? More likely the case to director, personal prosecutions, director disqualification. Those people, so two things I'd like to raise, and I think it is, you know, that it is important that health and safety is at the forefront, and obviously it is at the moment, particularly sort of almost sideways through Grenfell Tower and all the rest of it and the stuff that Laura was talking about earlier. But when we've got IOD and HSE saying, hey, to directors, please grab hold of health and safety. You're the people who can make a difference. Do something about it. And at the same time, you're getting 3 times as many directors being prosecuted. You're getting easier to be prosecuted when you're close to the job. So organisation where you can really make a difference, where in small organisations where most accidents happen, the director is very, very close to what's going on and very, very influential in how things are being done. So I'm just worried that there's a mixed message there, and that in some ways this emphasis on directors and prosecution and this thing about people getting custodial sentences a lot more than they're used to, etc., is that going to encourage that leadership? Is that, I mean, it should do. Everybody, the right thinking person should say, yeah, everybody do that. But it's going to be quite a decision for people to do that. Are they going to think they're putting themselves right in the firing line? Are they going to seek ways of separating themselves from that firing line? And if they separate themselves from the firing line, they'll lose their effectiveness as leaders in health and safety. So just put that out to you. Personal thought, not the thoughts of Ashford's or any other organisation I'm associated with, just musings in the shower, those sort of things. So anyway, on to gross negligent manslaughter. We've had the sentencing guidelines for health and safety offences and food offences as well, and those things. So now we're looking at on individual gross negligent manslaughter. So have I gone back to that? I've been shooting about all over the place. Still got plenty of time. Covers 4 types of manslaughter: unlawful act manslaughter. Well, you might think that's health and safety worked out, but it's really sort of things when things go wrong, an arson or robbery where there's a fatality. It wasn't intended, but is a consequence of. Manslaughter by reason of loss of control, fairly straightforward there. Manslaughter by reason of diminished responsibility. And what we're interested in gross negligence manslaughter. So we've had all the sentencing guidelines, and we've heard about, culpability levels and things going up and down and turnovers and all that, but this is individual, and now this is individual gross negligent manslaughter. So separate from what we've been talking about up to now. And this has gone through its consultation period, finished in October this year, and in theory the sentencing guidelines should be in place by the end of this year, 2018. And we all know what the sort of effect of the sentencing guidelines on health and safety offences have had, so this should be quite interesting to learn from this as well. So, there's the link at the bottom there for people who want to look at the consultation and all the rest of it to follow up on this talk. So, looking at gross negligent manslaughter, there's all the blurb there, but taking out the stuff that we might be interested in. Breach of duty of care which amounts to a criminal act or omission or causes death. And in a medical situation, a practitioner falls far below the required standard in the treatment of a patient. I put that in there for a couple of reasons. There's a case I want to talk about in a minute. But also if you think about how... I'm getting a bit of feedback here. If you think about how individual gross negligent manslaughter before, when we talked about it before, when we were talking about corporate killing and the differences and all the rest of it, and we were talking about the standard case for that was the Adamarco case, which was a medical case. If you remember, it was the anaesthetist who was in charge of the patient. The tube was blocked, the air tube was blocked to the patient, and the patient sort of started suffering. The anaesthetist didn't see that, didn't see the blockage in the tube, which apparently could be seen, and didn't see the machine was telling him that thing was going wrong, and that looked as gross. So, putting that in there because the history of individual gross negligent manslaughter is wrapped up in the medical processes there. But also at work, and it says that, this is a direct quote from the documents. It says, employers, who disregard the safety of their employees. We'll put a bit more flesh on that in a minute. Main recommendations, the consultation document says, in considering the factors that make the offence of gross negligent manslaughter more or less serious, the Council came to the conclusion that it would be appropriate for sentences to increase in some situations. So again, talking about the same sort of thought processes that were the sentencing guidelines that we've had recently, the idea that people weren't getting the right sentences, so let's give the judges a bit of a hand there. Typically, these are cases where an employer, this is the employer, has had a long-standing utter disregard for the safety of employees and is motivated by cost-cutting. But there may be other analogous factual scenarios where sentences would also rise under the proposed guideline. The aim of the guideline is to ensure that sentences are consistent based on fair assessment of culpability and harm and the circumstances of the offender, regardless of the factual scenario. So again, the word's quite interesting to us, utter disregard for safety of employees, motivated by cost-cutting, those sort of things there. So personal prosecution, gross negligent manslaughter, new guideline, currently under consultation. Well, it's not, it's finished. Similar processes, culpability, starting point of range, aggravating, mitigating, guilty plea credit, and totality. So those are the things that are taken into account. Okay, culpability. Let's have a look at culpability, always worth a look. Very high culpability. A lot of you won't be able to see this, so I do apologise. Some of you are putting glasses on, some of you are taking them off. I'm getting to that age as well, you know. Some of you are looking for the right glasses. Well, you won't find it, it's too small. But anyway, these slides will be on the website, won't they? So, if we remember this, if I remember. Right, so very high culpability may be indicated by the extreme character of one or more capability B factors, so B factors is underneath, and a combination of culpability of B factors. So that's talking about B factors, and so B is the key thing here. So factors indicating high culpability. The offender persisted in negligent conduct in the face of the obvious suffering of the deceased. The negligent conduct was in the context of other serious criminality. The negligent was so those things are not, you know, maybe have health and safety sort of ramifications, but not, you know, not the most common. But the negligent conduct was motivated by financial gain or avoidance of costs. We all have discussions about those at some stage when we talk about health and safety. And the negligent conduct persisted over a long period of time, weeks or months. The offender was in a dominant role. In fact, the offender was clearly aware of the risk of death arising from the offender's negligent conduct. And the last, my favourite, concealment, destruction, defilement, or dismemberment of the body were not separately charged. I like the separately charged bit there. The separately charged bits of the body, I don't know, it's going on there. But anyway, so those are the ones that we're particularly interested in. Negligent, motivate financial gain over a period of time. Those things there. But factors, C factors, cases falling between the higher and the lower, so we're still talking about B, so B is the important bit there. Factors are present in higher and lower which balance each other out, and the offender's then lower culpability. The offender did not appreciate the risk of death arising from negligent conduct. The negligent conduct was a lapse of the offender's otherwise satisfactory standard of care. Okay, you can see some of the sort of relevance to some of the things we talk about. The offender was less a subordinate role and acting with others. The offender's responsibility was substantially reduced by mental disorder, learning disability, or lack of maturity. So anyway, so you've got the culpability, and those culpabilities A, B, C, and D. If you remember, B is the key one. It's the high culpability, and A and C really refer. A says we're sort of nasty B, and C says we're less nasty B. Aggravation, mitigation, not invented, so back to the usual sentencing process that we're quite used to. So that's on its way. And again, I'm thinking back to this sort of idea of punishing individuals. So again, not only what I was talking about earlier, about custodial sentences as opposed to things, but also we've got this other thing coming in with looking at employers and all the rest of it. And you might say, with some of those things, you know, if they dismember and separate the body parts and things like that, they deserve to go to jail. And I'm with you. I'm totally with you on that. But there's some other things, perhaps a bit more complex, we should be thinking about there. So anyway, this recent case is quite interesting for gross negligent manslaughter. Honey Rose was an optometrist, convicted. This is convicted in 2016, but it's been to the Court of Appeal last year. So convicted of gross negligent manslaughter for the death of a young child, Vincent Barker, following a buildup of fluid on his brain. So what happened was that he went to the brain, and there's a test that optometrists should look at with children, looking at a retinal scan or something, but looking into the eyes, and that this medical condition would have been seen. It's something that they look for, and it would have been seen. But she didn't do the test. So she didn't do the test, it wasn't spotted, and poor Vincent died quite quickly. And so she was charged with gross negligent manslaughter, and she was convicted of it. So this bit up here, this is about the appeal court. This up here was the conviction. So when I'm talking about the court held this and the court did that and all the rest of it, I'm talking about the appeal court. So the first court convicted her. Went to the appeal court, and the appeal court said, held a serious, there was definitely a serious breach of duty there, but it did not constitute gross negligent manslaughter. And I know this is a medical thing, and some of you aren't deal with medical situations and things like that, but it does have ramifications and transferability into more the things that we are interested in. But serious breach of duty, that did not constitute gross negligent manslaughter. So she didn't do the test, that's a gross breach, but is that gross negligent manslaughter? And they said no. Concluded that the jury, in this first case, that the judge misdirected the jury when applying the test of foreseeability. Remember, foreseeability is everything. If you can't foresee that something is going to happen, how can you be expected to do, so far as reasonably practicable? Can you sort of step into that ground and say, so far as reasonably practicable, this is what you're going to do? If you cannot foresee what you're supposed to be doing to be guarding against, is there a reason? So foreseeability, if you remember, is always the key. So, misdirecting and applying the test of foreseeability to the outcome of the death. Noted earlier, decision would have serious implications for all medical professionals. So we've got here saying, hang about, let's look at the technicalities of the law. And here, a bit of a policy hang on at the end there. That if this went on, it's going to put other medical practitioners in this position in quite a difficult position. A bit of a sort of lateral digression here, but if you think about years ago, I can remember me and Kevin being stuck up here when we were talking about school trips. And if you remember, then there was this movement by the government away from the fact, no, we want school trips, so we're going to these cases where scouts, masters, and people like that were being prosecuted because the risk assessments on school trips and things like that were not deemed adequate. They're moving away from that and saying that it's going to make it more difficult to prosecute in those situations. Again, this sort of thing is if you go too hard in one direction, you're going to discourage people from the sort of behaviour that you want them to do, which is going to, say, medical practice and things like that, and particularly be worried about judges looking over their shoulder all the time. So a slight digression on that. So when you look at that, you say, well, is this correct to start thinking in that way? Well, you've got to look at it on the wider sort of scope of things. Anyway, still with the same case, because it's very important, this case, and the way it's looked at, and it will have, if you think about it, it will have ramifications. I'll come back to it in a tick. It is not appropriate to take into account what the defendant would have known but for his breach of duty. Were the answer otherwise, this would fundamentally undermine the established legal test of foreseeability in gross negligent manslaughter, which requires a proof of a serious and obvious risk of death at the time of breach. So, rattle that off to you. So what that means is that at the time, yes, there was a breach, didn't do the test. But when not doing that test, it wasn't obvious what that test would show. And that's what we're looking for. When we're looking for foreseeability, we're looking for the serious and obvious risk of death at the time of the breach. So at the time of the breach was not doing the test, but you didn't know what the test was going to bring, so that you didn't have that You didn't have that obvious, serious and obvious risk of death to foresee at that time. So is there a problem with that? There you go. What have we got?
What is the test for?
The test is, for an obvious risk of death. You've got to be able to foresee an obvious risk of death at that time.
Carry out the test.
Yeah.
Test, you missed the
Yeah. So basically, you're almost getting away with it because you're not doing the right thing, if you look at it that way.
It was a standard test.
Standard test, yeah. So, what do we think about that? Sorry, come on in, Peter. Richard. It's not ignorance on that, it's foreseeability we're talking about. Is it foreseeability? I don't know what you're saying, but you could still have foreseeability. If you think about what was the case, Baker and whatever, sorry, joining in me there, I was like, we're conducting the orchestra here. Is Baker, where it said, a couple of years ago, the Baker case, where's the deafness, industrial deafness, where it said, it clarified that area of law where it said, you cannot be, to do everything reasonably practicable, you've got to be able to foresee what you're going to be doing against. So, but Levison helped us with that, and I think it's the point our colleague at the back is making. Hang about, she got away with this on the basis of not doing the right thing. And he said, well, actually, the serious of breach, hang on, yeah, there are other things to look at. I'll come back. So serious breach by itself will not constitute manslaughter. Foreseeability is even more important than normal. There must have been a serious obvious risk of death, which I think is Richard's question on breach. Foreseeability cannot take into account information that was missing because of the breach. Again, so we're back to this idea. Okay, we can't have manslaughter because she didn't do the test, which was a breach, which seems there's a sort of wrong circularity there.
How does this potentially affect asbestos case?
I was thinking about asbestos case. Can I come back to that in a tick? Okay, so effectively, an example here, my colleague Jack thought it was an HSE example. It's not HSE, it's not a case, it's a bit of it's a health and safety example that has been made up. Individual A fails to risk assess the impact of works on a nearby wall. The wall shows no obvious sign of fragility or weakness, but a proper assessment of a qualified individual would have shown that the wall was at risk of collapse. The wall collapses, something goes wrong. Not guilty of gross negligence manslaughter, there's no serious risk of the death. The fact that a proper risk assessment would have raised the issue cannot be taken into account. Better to a blind eye? No. Failure to assess at all would result in other health and safety charges. So we're getting back to that. There are other health and safety charges, as there are other regulatory charges for Honey Rose. Sorry.
Wilder got sent to prison for killing a 6-year-old girl because he didn't do an assessment of the boundary wall that collapsed.
Right.
So I don't know where they got that from.
No, it's not them. It was a made-up one. So it is, yeah. So it's basically we're trying to extrapolate on there. So if there is a wall and it says that there is foreseeability that you should have looked at that wall, and there's something about that wall that gives you some that you should test it. It's in a position where near a school or something like that. Then we're in a slightly different position. What we're looking at is a situation where you're in a situation where you have a choice where you can do a set test, like in Honey Rose, and you don't do it, and something goes wrong because you don't do that test. And we come back to the asbestos there, because I don't know where you're thinking about people doing this demolition test and all the rest of it, and those things. Not doing that test, you're not guilty at that point, but there are offences afterwards. And your point is quite proper there, that with Honey Rose, and I think Levison makes this point, we add that this decision does not in any sense condone the negligence that the jury must have found to be established at the high level in relation to the way that Miss Rose examined Vincent and failed to identify the defect which ultimately led to his death. That serious breach of duty is a matter for her regulator. And in the context of this case, however, it does not constitute the crime of gross negligent manslaughter. So back to your example, that person, I don't know the background, it was gross negligent manslaughter, but it could have been a regulatory offence under health and safety workout, management regulations. You did not do a risk assessment and therefore did not inform yourself. But those are regulatory offences as opposed to individual gross negligent manslaughter.
I think in that, I'd have to go back and reread it. My recollection question is that he was prosecuted and found guilty under manslaughter.
Okay, so isn't that situation? But again, it's the foreseeability side of that. Defect may be more obvious, or it may have been, you've got to foresee, you say, well, is there a more vulnerable population nearby, so you have to step in and do those sort of things there. Back to the asbestos case, yeah, is your point then that if you don't conduct the right survey, that you get right?
And the historical ones about whether, so I'm thinking of maybe exposure that happened 30, 40 years ago. And so when you're talking about the foreseeability at the time of the breach,
Yeah,
see what I mean?
at the time of the breach, again, which is that case, which I think is Baker, and I can't remember what the case is, Baker, which said also foreseeability is timed into the state of knowledge at that time. So move on. But I was thinking about asbestos, if you don't have the right
Yeah,
survey, you need to take it out, because I've been involved in lots of cases where people say, well, we had a survey done, and then it was decided that there wasn't the right level of intrusiveness on that survey to carry it through and things like that. But I suppose in asbestos, you'd have to be a mesothelioma does act quite quickly. But that's the trouble with all sort of health situations. That's the situation of that, is the long sort of gestation period and all the rest of it, and how it'll work on there. But anyway, so one of colleagues before said, well, recently said, how about this health and safety practitioners? Because all this thing on individuals and directors and things like that, there's a lot of health and safety practitioners in the room, so how does it affect you? I don't think it's a real big issue. There's not been a sort of history of health and safety practitioners being found in breach and having serious prosecutions against them, but there's this famous one in Golding in 2015. But as you'll see on this, trench collapsed, consultation visited site did not identify unsupported excavations. So we're in a trench, unsupported excavations are fairly obvious. I remember Kevin being up here and talking about the Geotech case. It's not surprised that the first ever corporal manslaughter case was with a trench of things like that, because it's so obvious. So very, very obvious and so preventable and all the rest of it and things like that. So it's not surprising that, the first real custodial sentence for safety practitioners in recent years has been in that situation there. You remember this section 7, so I better speed up a bit. No, I'm not, I'm doing all right for time. Speed up, general duties of employees, section 7. Again for health and safety advisory, criticised by the prosecution because this was the one that went to jail, method statement, held blah, 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 and all the rest of it, but it was unsupported excavations, for Christ's sake. So, and it's their job and they didn't notice it. Other health and safety practitioners, to consider, there's some cases there, but as you can see, it's people really, really overstepping the mark and getting themselves doing things they shouldn't have done, been told that they shouldn't do it because they're not qualified to do it, and then carrying on anyway and putting other people in danger. But again, with health and safety practitioners, I suppose that is something in the Honey Rose case that we're talking about. Not the poor old optometrist, poor old Vincent, but the optometrist who was caught there who didn't conduct that test that would have been there. And back to the case that we've been volunteered about the wall, somebody didn't do a risk assessment, what sort of liabilities is there? And it's all to do with foreseeability at the time of where that test is. So you're not automatically, if that test isn't done or that risk assessment isn't done, you're not automatically being looked at for corporal manslaughter. There are other things, section 7 with practitioners, but there are other regulatory offences that are more appropriate in those situations. Okay, so related then, another thing last year is the early guilty plea. And this is probably, well, I suppose closely related into this. Previous guidance, maximum off your guilty pleas, which is a third off. First available opportunity. When was the first available opportunity? What, anybody? Sorry?
You were charged.
That's what people think now. But it used to be when you turned up in court. But it used to be when there wasn't any sort of specific. It was a reasonable decision to be made. So Nowadays, it is basically the first available opportunity is your first up in court. Whether it's in a magistrate's court, whether you're going to stay in a magistrate's court, or you're going to go into the magistrate's court and be bumped up to the Crown Court, it's when you turn up in court. But I'm sure Laura and any other lawyers in the room will be familiar at a time where you serve with papers and the first update is a week away. And you're there in court and you've got 12 minutes the first up sort of hearing and things like that. And it's very, very difficult. In those situations, in previous times before this came in, you just turned up in court or you try to get the court date moved and just say, look, I got the papers a few weeks back or a couple of weeks back. I'm not in a position to make. Or even got the papers a couple of months back, but this is a complex case. You've got to realise this is a complex case, and therefore we're waiting for our expert report, and then we'll be in a better position. And it was accepted. The courts would accept that situation there. So first stage, after that the credit reduces, and obviously it's quite important because the cases that Laura's talking about, those high fines, a third off is quite a significant event in your fining and your financial accounts. A third off, what's Tesco, 8 million, a third off, that's a few bob. A few, that's more than a few Green Shield stamps for those of us who can remember on that. So, implications. Prosecution case papers are often not available till shortly before the first hearing. Health and safety cases are often complex. Defendants have little time to get, this is defendants' lawyers, just moaning now. But here we go. That's what I am. So complex, defendants have little, even if a prosecution paper expert might be needed. Sorry, that's all right. Julian, I thought you were passing away or something. But there you go. New sentence guideline for early guilty pleas. Exceptions. Where the sentencing court is satisfied that there were particular substances which significantly reduced the defendant's ability to understand what was alleged or otherwise made it unreasonable to expect the defendant to indicate, say, oh, fine and dandy, that's great, we're back on track. So is the case difficult to understand? Facts of evidence. Is it reasonable to expect a plea ought to be made sooner? Possible in HSC cases, but not guaranteed. So we could make this argument, it's possible, but it's not guaranteed. There is this assumption that you're going to turn up at the first up hearing and you're going to plead. So you've got to make a case on that. However, there's a second part of that exemption, the second part there, in considering whether the exception applies, sentences should distinguish between cases in which it is necessary to receive advice and or have sight of evidence in order to understand whether the defendant in fact guilty of the offence charged, and cases in which a defendant merely delays guilty pleas in order to assess the strength of the prosecution evidence. Anyway, it's a wordy way of saying, basically, you should know if you're guilty or not straight away, and we don't want any delays for you saying, well, we'll decide if we're going to be guilty or not when we see how strong the prosecution is and we see how strong the evidence is. So again, it's putting, with such high stakes, with such high sentences, and it's not just a third off, and it's not just getting discounts for money, it's discounts for people with custodial sentences, etc., etc. So with these high stakes, this is making things quite difficult for a defence on there. So, the implications, guilty pleas for business expediency. Again, courts might think this is a good idea because it's going to make things quite quick. But again, can we afford to hang about? We've got this third in our pocket. We're not guaranteed to keep that third if we go to court and try and rely on that first part of that exemption, because the judge may feel, in fact, we're being disqualified by the second part of the exemption. So nothing is guaranteed. Should we go for our third off straight away? How are we going to make our decision? Again, as a defence lawyer, I wouldn't say that's the way that justice should be conducted. And also, so fast and action advice is immediate and crucial. And I was thinking back to this when Laura was talking, the very, very interesting part on legal privilege. What are you going to do about legal privilege? And what are you going to do? With legal privilege, you're going to have to start thinking straight away about how you start producing documents, how you're going to discuss with people, what sort of notes are taken and things like that, in what condition, and those sort of. So you're going to have to think very, very quickly to take advantage of the legal privilege that Laura was talking about, how you could do that. So you're going to have to make that decision very, very quickly. You know, are you going to have separate investigation reports? You're going to have a sort of prosecution, no, you can't say prevention, but a prosecution-related report as opposed to your investigation. All those sort of things, decisions made very, very quickly. Tied in with that is that quick decision-making again. If you're thinking you're going to be prosecuted and you're thinking about prosecution papers, again, you've got to be ready to move if you want to ensure that you want to be in the right position to make the right decision about the right plea when you're turning up to court, even if it's like 2 weeks after those prosecution papers have arrived. So this idea that you really, these days, you have to start thinking quite seriously about how you're going to conduct yourself, not only the investigations, but how you're going to order documentation immediately after an incident which you think has got the possibilities of going all the way, as it were, in terms of court processes. Okay, so there we are. Fees for intervention. I'll go through quickly on this because most of you probably know that the things that we've all moaned about in the last few years is called up with the HSE through a judicial review, the OCS judicial review, saying, you know, judge and jury. I've got had a letter day before yesterday from the HSE with one of my clients saying, thank you very much for disputing the fee for intervention invoice, but it's just we've sent it off to, and they named the person, and I know exactly the person. The person is in fact advising the inspector to give to follow through on the breaches in the first place, and that was the person who was deciding on the query, and therefore, funny enough, he decided that the invoice should follow on with a slight reduction. So this judge and jury thing, but now we got beyond that. Once we go beyond that, we still don't go back to the HSE to decide on themselves. We've got an independent hearing. So now we've got panel review, disputed invoices, fully independent of HSE, 2 members experience in health and safety matters, 1 independent lawyer to chair the review. So we've got some independence there. After this judicial review of last year, businesses received more than info from the HSE and what has been contravened, what investigations are carried out. It's quite good fun writing back to the HSE, sort of pointing out and saying, well, you know, what exactly are you telling us what went wrong and all the rest of it. And now they're going to be a bit more circumspect in providing that information up front. Very important, can suspend after investigation enforcement action completed. So can suspend the invoice or can suspend the dispute process for the fees of intervention until after the investigation, or if it goes to court or whatever, completed. Why is that important?
Could be acquitted.
Could be acquitted and you get your money back if you pay, but if you're not acquitted, you don't have to worry about refund because you haven't been charged in the first place. Any reasons? That is a point.
Might have gone bust with the fund.
Might have gone bust. Okay, you don't have to do that. Yeah, so remember, you know, we've been here before, there was myself or Kevin or so talking about this idea, if you pay it, are you admitting an offence in the first instance? And there are ways of getting around it, you know, if it's not much, if it's a few bob in the scheme of things, you say, well, you know, my client's paying this, but this isn't an admission of any liability. What this is doing is just getting you off our back because otherwise I have to pay lawyers who are going to be more expensive to contest this and it's all going to be a painful process, so please go away, here's the money. But it's not a liability. If it's a lot more money than that, then you don't want to pay it. Well, 1, you don't want to pay it because it's a lot more money, and 2, you don't want to, it's very difficult to argue that we're making this decision as a business expediency to pay you. It's not an admission of liability. So all that goes then, all that sort of argument and all that sort of problem disappears then if it's suspended until either investigation's completed and or it goes to court and the court decides whether in fact you have committed a breach. Okay, I want to get to a point after this, so I'll whiz through the business plan. I haven't really looked at it, but I've just got these headings up there, but it's the usual stuff. Leading, engaging those who undertake or influence health and safety, I don't know what that means. Ensuring regulatory framework remains effective, well, should be securing effective risk management and control through regulatory tools that involve direct interactions with duty holders, and reducing likelihood of low frequency, high impact, catastrophic incidents, and potential for extensive harm to workers and public. Very sort of Grenfell-esque there. Actually, I've just thought that when Laura was talking about the fire thing, that the Honey Rose case, sorry, I haven't just thought of it now, I thought of it earlier, but I forgot. I only just remembered it. So, the Honey Rose case, you think about the obvious breach at the time. Have a think, start thinking about some of the things that Laura has been saying about fire now. Fire's looked at. And how the investigation, the public inquiry is going to, some of the conclusions that some of you may be already coming to yourselves, whether informed or ill-informed, about what you think the conclusions of the Grenfell inquiry is going to be, about what would be foreseeable at the time. Talking about the cladding, whether it was and the building regs and all those sorts of things. So that might, if somebody was writing a dissertation or somebody's doing an MSc, that would be a very good MSc on how the Honey Rose case may have implications there. Anyway, so back to the business plan. Emphasise ill health through health and safety at work health and safety and work programs. So again, this movement, correct, very obviously correct. Emphasising health in the workplace. Very big going on in the construction industry. I have a lot to do with the construction industry, and there's a lot of things going on there with health. Reinforcing appropriate approaches, setting expecting standards, targeting intelligence, etc. Ensuring value for money for taxpayer by reducing reliance on government funding, improving efficiency and effectiveness. So fee for intervention is still with us, going to be with us. And bringing together breadth of capability, expertise across, and collaborating with others who have a stake in improving the health and safety in the workforce, in the workplace. And I hope you're very impressed that both Laura and I have mentioned the health and safety HSE prosecution of itself in the last year. A great self-restraint on that. Okay, this last point here, another sort of musing really. I do apologise. But I've been doing quite a bit of work with security organisations, security and things like that. I remember last year we talked about how security is spilling into health and safety or vice versa. And I was at a conference where the security experts, actually, I suppose it'd be quite interesting. Laura said, hands up those people who are involved in fire. Hands up those people who are involved in cyber security as well as health and safety. So one or two, a few more, not as many as in fire, but those numbers go the same. Because as I say, this idea of security and health and safety, if you remember, it was after the 7/7 bombing and the Menezes was prosecuted. The prosecution because of his death was under the Health and Safety Work Act of the Commission of the Metropolitan Police. So there is this balance there. But anyway, the WannaCry ransomware attack. Some of you will remember, well, I'm sure most of you remember, about the cyber attack on the NHS causing all sorts of issues and problems. And I was at this conference, and they had the lawyer there, and the lawyer was saying, looking on the civil side and going into the issues of the civil liabilities and things like that. But I was thinking, hang about, let's back to the foreseeability issue on this. If you think what happened with the WannaCry, encrypted the hard drives, infected demand, spread through exploits, older Windows systems, serious effect on NHS services, non-critical emergencies sent away, ambulances diverted, potential for a similar attack to be designed, actual attack critical infrastructure, dams, railways, etc. What is this to do with health and safety? Who knows? Let's get there. WannaCry could only attack either newer systems which had not been properly patched or older systems which were no longer supported by Microsoft. So this brought out a conversation at this conference where people were explaining their problems. Cyber officers and all the rest of it saying, we're getting all these things from software saying, you know, got to put this patch in, you've got to do this, got to do that, and slightly overwhelmed. But if somebody's going to say, you know, with the NHS service or any other sort of safety critical, nuclear stations or high hazard situations where computer control is an essential part of the safety management system. If somebody's coming through and saying, well, actually, we spotted a glitch in our system, here's a patch to fix it, and that person doesn't fix it, we're back to this discussion back with, you know, back to what's foreseeable. Is it foreseeable then that by not fixing that and something goes wrong, you get the NHS system, you can sort of think of things quite quickly of what could go wrong and all those sort of things. It might be somebody not being given their correct diagnosis or not being told to come back to have re-examination and all the consequences of that. You all see these negligence claims where they say, well, they should have come back, and if they had come back, they'd have discussed what their results were, and that would have resulted in interventions and all those sort of things. So I think again we're getting onto the borders now of cyber security and health and safety merging again, like we talked about security. We talked about that last year. And doing that. So it's just something I put out there. Somebody might have their own strong views on there. Foreseeability is such a powerful facet of it. You need to do it. Sorry.
Yeah, I was actually advised that 90% of the problem could be cured by logging on as a standard user.
I thought you were going to say turn on and turn off. Yeah, that was it. Yeah.
But a lot of programs will only work if you're logged on as an administrator.
Right.
And it's a problem, but I've been advised, and I don't doubt it, that if you were only logged on as a standard user, you've reduced your risk to be invaded by something like 90%.
Yeah. But there's that. So there's these tricks and things like that. But if you think about some of the big inquiries, say, I don't know, you think about Chernobyl. If Chernobyl, all those alarms go. If you look at what went wrong in Chernobyl, one of the things we're overwhelmed with alarms. Okay, and the criticism said, well, you're overwhelmed with alarms, so you're so overwhelmed, you didn't have an alarm management system. The same was with Texaco in 1994 when that blew up, when I investigated that one. Overwhelmed by alarms, so your alarm management system didn't allow you to pick out the actual alarms that were the ones that are going to be safety critical, because the low level or the low priority alarms were overwhelming the high priority alarms and it wasn't allowing that human interface. Just reminded me completely when I sat in that conference and people were saying, we're getting all these patches, and we can't tell which are the right ones to do and which are the right ones to implement. And therefore, they chose the wrong ones, etc., and there was some things like that. If you have consequences of that, if you have loss of life or injury or loss of dangerous situations and things like that, what's the difference between that situation and those situations, like Chernobyl and all the rest of it, where those things go wrong? So, you know, just another one of my musings as this talk was approaching, and I was wondering what the hell I was going to talk about this year. So here we are. Right, I think I've got to the end of my time, so there's a few minutes if there are questions before the usual dash to the doors at 12 or whatever.
I have a comment, actually. Not a
There's a comment, not a question. There's a hand. Hang